Hey guys, Dark Angel here. Uh, a lot of you know me, and a lot of you do not. And a lot of you for the ones that do know me, you know that I'm a no nonsense, no bullshit type of guy, and you know that I'm going to research. And if you knew anything about my other channel, with the hundreds of videos that I've had on that other channel, and the thousands of followers that I had on that channel was banned. For what reasons? They say too many community guideline violations. But anyway, we're not even going to get into all that. But this video, this case that you see on my screen right here, City of Chicago versus Collins. Now, I want you guys to know that this goes to all the haters, traitors, trolls, tyrants, everybody that has any doubts about your right to travel. And here's the thing about your right to drive an automobile on the open roads, okay? This case right here, it's an Illinois Supreme Court case back from 1898. Now, if you guys know anything about New York Rifle and Pistol Association versus Bruin, they introduced a new statutory procedure in that case. And what that does is it bases the determination of a statute on its historical aspect at the time of its enactment, meaning that once the statute was enacted, they looked to what type of restrictions was placed on the act that the statute references. Okay, so uh, same as such in New York versus Bruin. What they did was they looked to the historical aspect of the statute as to what type of restrictions did guns have at the time of the enactment of the statute. And as you know, in that case, they overturned the the uh, the regulations. So using that principle from Bruin, you're looking to the historical aspect of the statutes that require you to have a license to travel. Okay. And what we're going to do is we're going to go down through the case. And now, basically, this case here is about the fees. So if you go to 1915, Hendricks versus Maryland, uh, that case was also about the fees, which is some of the haters, traitors, trolls, and bootlickers, as well as tyrants' favorite case to cite, which I'm going to do a video on that case to show you the big difference about that case and why it's never used against us in a court of law. For those of you that don't know, just giving you a little taste of it, Hendricks versus Maryland is a commercial case. It is about interstate commerce, okay? It is about motor vehicles operating in interstate commerce. It's about the license fees, okay, that Mr. Hendricks uh, had to pay. Yes, he was found guilty in the case. Yes, we know all that. But what you need to know is the word interstate commerce is mentioned 25 times throughout that whole case, associating motor vehicle with interstate commerce. And the question of licensing on automobiles has never been presented before the court. So there's another historical aspect of no license required for personal private automobiles, which will be addressed in that case because I will be reading the case. Now, the majority of the case law that I will read to you guys is case law that I actually go right down the road from my house. There's a law library, and I print the cases straight out the books. Some I will come online to look at because based on the weather conditions, and I'm not going to get out the house. Like, for instance, today it's storming outside, so I'm not going anywhere. So, but like I said, for all of you guys that do know me, you know that I'm a no nonsense kind of guy. So for you haters, traitors, and trolls that's going to get on here and make negative comments, you will not even be addressed or even recognized. So just know that right off the rip. On my other channel, oh yeah, I engaged in arguing with you guys all the time. However, on this channel, I will not be entertaining your superficial thoughts. Okay. So what I'm going to do is I'm going to take you right down here to show you something. I'm going to take you right here where it says the legislator. The legislator had power to delegate to the city authority to enact the ordinance. Okay, this is about the fees again, guys. The ordinance is a valid exercise of the police power of the city. And then you can see these major cases right here. And the reason why I'm doing this slow is so that you can screenshot, stop the video, screenshot, and get these cases. Okay? So, but the most important part of this case is this right here. Okay, so if you look right here, even if the ordinance imposed the license and not a tax as claimed by appellant, it is invalid because unwarranted by the statute. Okay, and here's a whole slew of case law that he added. The ordinance is void because unreasonable, oppressive, and violative of constitutional rights. Okay, there's the case law he added there. The ordinance is a tax and is invalid because it is not uniform and constitutes double taxation. Okay, Titleman on limitations of police power, section 381, Cooley on taxation, etc., etc., etc. So basically, here's where, this is the reason why I wanted to skip all that. To show you exactly what the justice delivered in their opinion. Okay? Because everybody has always been wondering, has that ever been written in an opinion or, you know, by a Supreme Court? Again, this is the Supreme Court of Illinois. So it's not the United States Supreme Court, but it is a Supreme Court of Illinois. And here's the interesting thing about this, guys. This is historical facts as well as providing cases all around the United States of America that has ruled in this favor. So, when a cop pulls you over and he tells you that the right to drive is a privilege, no, the right to drive in commerce is a privilege. The right to drive as in traveling is a right, always has been. So let's see. I'm going to get you right to the point. We're going to look at it here in a minute. The claim that the failure of complainants to pay this tax and resort to legal action to recover the amount precludes equitable interference and cannot be sustained. Many cases undoubtedly exist where equity will interfere to protect an invasion of property rights, where the remedy of law is not entirely adequate and where particular difficulties intervene. The jurisdiction will be upheld. In the present case, 373 complaints have filed their bill for relief. Their grievance is precisely the same and arises from the same case. The various parties aggrieved, although not jointly interested, are allowed to sue together for the express purpose of avoiding a multiplicity of suits and to have the controversy settled in one hearing. The municipality is charged with a public trust, and where it is about to commit an act clearly illegal, the unnecessary effect of which will be to impose heavy burdens upon the property of citizens and taxpayers, it becomes amendable to the jurisdiction of equity for a breach of trust, and such court may interfere by injunction for the prevention as of such act. Where the controversy is between two parties only, or where but few persons are involved, then unless complainant's rights have been established at law, established at law, a court of equity will not interfere. Okay, so basically, what I'm doing is I'm going down through here looking for the most important part of this case. And the funny thing is I've done a video on this already. Okay, I've done a video on this on my other channel, and for some reason, this case here for some reason has listed a lot of things. Okay, so here we go. Right here where it says the principal. The principal contention of appellant is that under Clause 9 of Section 1 of the Act, which grants power to the Common Council to regulate the use of the streets, the implied power is conferred to require a license to use the streets. It has been frequently held by this court that the power to regulate being expressly granted, the power to license is a means of regulation as clearly conferred. Okay, now look at the case law here. Chicago Packing and Provision Company, City of Chicago, Kinsley versus City of Chicago, and Banta versus City of Chicago. Okay, but look what it says. The streets and alleys of a city are held in trust by the municipality for the use of the public, for purposes of travel thereon as a means of access and to the egress from buildings abutting thereon or lots adjacent thereto. The right to travel on and along the streets of a city belongs to the general public and does not belong to its denizens alone. The right to travel being in general public everywhere, all persons have a right to pass along and use the streets and alleys of a city in all their parts and full width and length thereof. The municipality, which is a mere trustee of the public and holds the streets and alleys in trust for the public, cannot deny the right of the public to use the streets and alleys. It cannot assume an exclusive ownership and deny the rights of the beneficiaries under their trust and arrogate to itself a power greater than that of a mere trustee, and prevent the use of the streets or the alleys by individual members of the public. The right of the public to use the streets to the right to use them for purposes of travel in the recognized methods in which the public highways of the state are used. Any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion or even an extraordinary method. Now, for those of you that know me, know I'm going to explain this to you. Okay? Ordinary method is the right. Okay, meaning that is an automobile and or a vehicle not operating in commerce and or doing commercial activity. An extraordinary method is any vehicle operating in that of commerce and commercial activity. For those of you that don't know the difference between those two definitions, that's what they are referring to when they say ordinary method of locomotion or extraordinary method of locomotion. Okay? If it is not of itself calculated to prevent a reasonably safe use of the streets by others, it is a right exists in the city council to impose a license fee by way of tax on every person using wheeled vehicles thereon. It may in like manner impose such license fee for such use of the streets and every other manner of locomotion or travel, and reach the man on horseback or the pedestrian walking along the same. The right conferred on the city council by legislature to regulate the use of the streets and alleys of the city did not contemplate a power in a trustee of a beneficiary to deprive that beneficiary of a right. The power to provide by ordinance, by planting trees in streets, to prevent encroachments upon or remove obstructions from the same, to provide for lighting and cleansing them, to use, prevent, and regulate the rolling of hoops, playing of ball or flying of kites therein, or to prohibit any other amusement having a tendency to annoy persons, is conferred for the purpose of keeping the streets in a condition for public use and travel. Pay close attention to what I'm getting ready to read to you guys, okay? Because what I'm getting ready to read to you is the gem of the gems, the gem of all gems. Any usual method of travel along the streets and alleys of a city cannot be declined to be a nuisance, cannot be declared to be a nuisance. The city council may regulate the use of the streets and alleys to the extent that it may require sidewalks exclusively reserved for use by pedestrians and exclude certain characters of loads and regulate the width of tires on vehicles used on a certain character of pavements, and provide that the rate of speed shall be much less on certain streets than on others, and otherwise regulate the use of the streets having in view solely the welfare and safety of the public. The city may also regulate certain occupations. Did you guys hear that? Such as hackmen, drymen, expressmen, and the like. For such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions, and extortions. Traffic tickets, for those of you that don't know, traffic tickets are instruments of extortion. And for the same reason, a license, listen, a license may be exacted for vehicles used in the transportation of goods and merchandise, or of passengers, or for other purposes of traffic, but such license is an occupation license, and not one for the use of the streets. The license, did you hear that? And it's not one for the use of the streets, meaning you don't need a license to use the streets. That's what it's saying there, in the event that you're wondering. But listen here, guys. This is here. The license in the latter named case is designed to operate upon those who hold themselves out as what? Common carriers. And a license may be exacted from such as a proper exercise of police power, but no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. There you go, guys. Right there. Nothing but facts. Supporting cases. You go look up these cases, and then they actually add more cases, and it keeps continuing on to other cases that end up all around the country. How do I know this? I know this because I've done this research already. I've done a video on this on my other channel, and it got over 3,000 views and over 3,000 likes. So therefore, like I said, this right here, if you read this part of the opinion, they diverted the opinion from the fees to the actual license. They're telling you that a license is a license of occupation. It always has been, guys. For those of you that never knew that, or didn't know that, or thought you knew it but couldn't prove it, well, here's your proof right here. License has always been an issuance for occupations. And as you see right here, okay, it says, but no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. So, to all you haters, traitors, and trolls out there, and tyrants out there who don't know, okay, the right to travel does include driving your automobile on the highways. It always has and always will. Okay? That's for all you haters, traitors, trolls, and tyrants out there that don't know the difference between what a right is and what is a non right. Well, I just put it out there and showed you. That is your right, people. Now you go through, and the only reason why I'm leaving it on this right here is so that you guys can stop this video, screenshot this screen, look up these cases, and follow through and look up the other cases. Okay? Anything which cannot be enjoyed without legal authority would be a mere privilege, which is generally evidenced by a license. Cate versus State. 3. Cited 120. The use of public streets of a city is not a privilege but a right. Open and free to the public. Guys, you got to remember that. The use of the public streets of a city is not a privilege but a right. Titleman on limitations of police power, Section 281 says, in distinguishing between a license and a tax, it is therefore conclusive that the general requirements of a license for the pursuit of any business that is dangerous to the public can only be justified as an exercise of the power of the taxation or the requirements of compensation for the enjoyment of a privilege or franchise. In Cooley on taxation, it is said a license is a privilege granted by the state usually on payment of a valuable consideration. So why in the world would you want to give up your rights to pay for a privilege? Because if you think about it, every single privilege you have, you're paying for it. Every right you have is free. Bet you a lot of you guys never looked at it that way, did you? A license is a privilege granted by the state usually on the payment of a valuable consideration. Though it is not essential to constitute a privilege, the grant must confer authority to do something which without the grant would be illegal. For if what is to be done under the license is open to everyone without it, the grant would be merely idle and nugatory, conferring no privilege whatever. A license, therefore, implying a privilege, cannot possibly exist with reference to something which is a right, free and open to all, as is the right of the citizen to ride and drive over the streets of the city without charge and without toll, provided he does so in a reasonable manner. That such a right exists in Chicago is recognized in Smith versus McDowell. Okay. Wrote, it was said, relative to the streets of a city, the grant of power in this particular is to be construed in view of the purpose for which the municipality is invested with the control of its streets, alleys, and public grounds. The municipality, in respect of its streets, is a trustee for the general public and holds them for the use to which they are dedicated. The fundamental idea of a street is not only that it is public, but that it is public in all its parts for free and unobstructed passage thereon by all persons desiring to use it. Ladies and gentlemen, boys and girls, you have just been educated on the fact that you do in fact have a right to drive your automobile traveling. I am also going to refer you to another case that I am going to do a video on, Swift versus Topeka. You might want to ask somebody. Like I said, I do this. I've been doing it for 40 something plus years. I don't care what the haters, traitors, trolls, bootlickers, and tyrants say. I've had 2 tickets in 40 years, both tickets both dismissed in the best interest of justice. I know what I'm talking about. I've been doing this for a long time. And this right here, you need to put it in your arsenal. This is Dark Angel, guys. Deuces. Oh, by the way, please like and share these videos, man. Let's get my subscribers back up to where they were. I was up in the 3,000-4,000s on my other channel. Let's get this channel back up there too. Get the likes up. Let me know that you like these videos and that you like this information, because that's all I do is provide you with facts over here, not bullshit. All right. Anyway, this is Dark Angel. Deuces, guys.